I said our lawyers don't dance, we just grow and enhance, yeah. Legal knowledge today. Now legal back, legal back, legal back, legal back. I said our lawyers don't dance, we just grow and enhance, yeah. Legal knowledge today. Now legal back, legal back, legal back, legal back. Law and Too Easy. K-Mark to the Lizard. Let me stop. Thank you for joining us today. I am Marquel Cade with Cade Mark Law, your favorite neighborhood lawyers, back with another resource for you. Today, we talk video gaming and IP. 3 things that you need to know about protecting video games. Now, as you can see from my overt enthusiasm on today's topic, I love video games. I love video gaming. It's a great stress reliever. It's a great hand-eye coordinator. It's a great way to just kill time. It's a great way to escape. It's a great way to explore great stories, which is why a lot of new IP are following copying video games for their TV series and movies. But I digress. The first thing to know about video gaming and intellectual property is that video gaming consoles, hardware, controllers, accessories, and things like that are typically going to be protected under patent law. Patent law, if you remember, is the thing that covers inventions. So typically speaking, your PlayStation 5, its controllers, your PlayStation 5 VR if you have one, all of the accessories and peripherals that go with that system, or if you're an Xbox or PC gamer, your Steam Deck or your keyboard or those mouses that you use, all of those accessories are typically going to be covered and protected through patent law. The second thing to know about video gaming and IP is that video games are also protected by copyright law. Things like your source code, your artwork, your music, your sound, the in-game text, all of these things are going to be covered by copyright law. So video games have to also seek copyright protections for things like the music that they use, the source code that makes up the game itself, the art that's in the game. These types of things are protected through copyright laws. The third thing to know about video gaming and IP is that not only does it invoke patent law through the protection of the hardware and accessories of the system you're using, and copyright law through the artwork and sound and even the source code of the game, but it also uses trademark protections. Video gaming needs trademark protections to protect things like the video game's name if it's in a series, the logo of the video game, the company name. These types of things are protected through trademark law, which is actually interesting because it brings you a fun fact that you can take and use at your next dinner party when it comes to video games and IP. Video games are unique in that they are one of the few types of properties that invoke all 3 types of intellectual property protections. They need patent law, they need trademark law, they need copyright law to fully protect the game, which means video game creators, video game studios, and indie companies would be remiss if they did not have an attorney helping them protect these things. Not only that, but these companies also have to have work for hire agreements, because remember, the creator of the work is the owner of the work, which means that if someone is coding or developing or creating the artwork for the game without a work for hire agreement in place, they're the owner of the work, not the video game studio or the video game company or the indie startup that's creating the game. Licensing is also important. Without licensing, we don't have video games like Insomniac's Spider-Man 2, for example. And it also goes both ways. We don't have the current Halo series on TV, for example, because Halo started as a video game. They had to license that property out to Paramount so that they could make the TV show. Licensing agreements are becoming ever important when you think of things like The Witcher on Netflix. That also started as a video game. Video game IP is becoming increasingly valuable as Hollywood runs out of ideas on new movies and TV shows to create. When you have the new TV shows or movies coming out nowadays, they're going to be coming from books and video games, which makes these licensing agreements all the more important. You want to make sure that you have strong legal counsel in place if you're developing a video game or if you're developing a novel, because odds are, if it becomes popular enough, or if just the right person finds it even, you could find yourself in a position where you need to license that material out. You want to still keep ownership. You want to still keep that revenue flowing. Hell, you created it. But you also want to be able to leverage that IP to bring you extra money, to bring you the ability to create more IP, to grow your company, to protect your brand and grow your business. That's all, folks. Thank you so much for joining us today. This has been 3 things that you need to know about video games and intellectual property. I am Markwell Cade with Cade Mark Law, your favorite neighborhood lawyers. Protect your brand, grow your business. Stay frosty, my friends. We'll see you next time. We hope this was helpful.